uh, motion to withdraw as counsel of record. Your motion says that you have fulfilled your obligation as attorney on behalf of the estate. You got a notice of hearing. Looks like you served it on Ms. Merrill.
Yes, sir.
Okay, tell me about this.
629. Judge, I was retained to represent Ms. Merrill and take care of this estate for her, and I have done that and completed all of my duties. And I spoke with her Friday afternoon. She called me and told me that she couldn't be here this morning. She's starting a new job or something. She had already called us previously, Judge, and we had rescheduled to today. And so to accommodate her and make sure she could be here if she wanted to be here. But she called me Friday and said she had started a new job and couldn't take off. And she had a phone that wouldn't allow her to somehow to participate. And that she said, Judge, send her whatever she needs to sign. And so that was basically the extent of my conversation with her. I could get into more detail, Judge, if I had to, but I didn't know if that would be appropriate in this hearing.
Okay, has there been an inventory file?
Um,
I don't even see an order admitting the will to probate.
Judge, there was an inventory filed August 22nd, 2019, if my information here is correct.
Okay.
And
Looks like there's something in there with Wells Fargo, though.
yes, sir. Wells Fargo and a property, $90,000 value in Port Arthur, 3409 9th Street. So that's the inventory. I assume, Judge, I have the file and confirmation. So I think we've done that. And so you're not seeing an order admitting the will to probate?
No, it must be in the file in the clerk's office. So it's online.
Okay. This is stamped, an inventory stamped August 22nd, 2019. And the order approving the inventory was August 23rd, 2019.
Okay, is the representative of the estate still dealing with its state creditors?
Judge, okay, I'll just tell you that I have very little communication. I don't hear from her. What happens is I've heard from an attorney that the court has known for many years asking me about the distribution, and I had a good deal of difficulty in getting in touch with the client about the distribution, and she assured me that she was taking care of that and everything was okay. After that, I had a call from Mr. Rick Lewis, who advised me that he understood that everything was worked out between the executor and the other beneficiary. So I stopped worrying about that. And then I got a call later, several weeks or a month or so later, that the problem still existed, and that some sort of accounting was going to be requested. So at that point, I decided that, well, I've, as far as my position is, I've completed my duties that I was retained to take care of. And even Friday in the conversation, my client advised me that she had resolved the differences that she had with the beneficiary of the estate. So maybe she has and maybe she has not, but I didn't feel like I was retained to get into all of that. And I think Mr. Brandon Monk sent a letter or may have filed something. Mr. Lewis didn't actually get involved in it, but I think Mr. Monk may have
Did Mr. Monk file something?
taken some action.
Okay, we don't have anything yet, so.
Okay.
All right, I've signed your withdrawal order.
Okay. Thank you, Judge.
All right, have a great
You
week.
too. Thank you. Okay. Bye-bye.
This is really- thanks, man.
phone, make sure that there's not.
Not even. Oh, that. He didn't file it with the motion.
Hello?
Okay, I see Mr. Wood. I hear, I think, Mr. Shake Snyder, but I don't see him.
I see you on there.
Okay, you'll need to enable your video, bottom left-hand corner.
The host has asked you to start your video. Yeah, okay, I'm on there.
Good morning.
Good morning.
Morning, Your Honor.
All right, looks like we have everybody here. We're here on cause number 125010, the estate of Maxine Lila Lovelace, deceased. We're here this morning on a motion to fulfill that was filed on May 6, 2021 by Mr. Wood. It's my understanding that Mr. Wood, on behalf of Robert Craig Lovelace and Ronald Allen Lovelace, he served a request for disclosure of production on 2021, which would have been due on April 9th. It's also my understanding Mr. Wood's email dated May 4th, 2021 to Mr. Shakespeare regarding the overdue responses, and we've heard nothing back. Go right ahead, Mr. Wood.
Your Honor, that is still the state of the facts today, and we believe that obviously we have a right to have our written discovery responded to.
Good. Mr. Shake Snyder?
Yeah, Your Honor, none of that stuff was served on me, either on my email address or through e-file. I talked to the county clerk's office. I thought I would automatically receive that from e-file, and they told me that I was on purpose removed from service on that when it was all served. Now, on the certificate of service, it says they served me by e-file and by email. Neither one is correct. I did send in exhibits the county clerk's record of who got served, and it shows where I'm not on there. I filed those as exhibits.
We have not received that here yet, whatever you sent in.
I'm sorry.
Whatever you say, you just say you sent in. We have not received here. We have nothing from you, Mr. Shakespeare.
I sent it in as exhibits in the last hearing that we were going to have, but my client got in a wreck. So I didn't make the hearing, and we have this hearing was that, but I've still never been served. Now, if I was to file an answer, it would be deemed like I was served. Now, since all of this came up, I've did somewhat of an investigation into the affairs of Miss Lovelace. I had no reason to do so before. I have a timeline somewhat that kind of starts in 2014. I'm not finished with, but as of today, I have not been served with any of that. The exhibits are attached to the filing that I did at this last hearing that I didn't make because my client got in a wreck. I had talked to Linda earlier that same day, but at any rate, but those exhibits were sent in that day.
What date was that?
The same, the date of the last hearing that we had for this case. I don't have that in front of me.
Yeah, we have nothing from you, Mr. Shakespeare.
Your Honor, I think my position with that is I think it's all fairly irrelevant. I did send him an email on May 4th to follow up about that. So this issue has been out here about our written discovery. And I really just would like to get an order ordering him to produce it in the court 14 days or, whatever the court wants, but just some type of backstop to to respond to the written discovery.
Your Honor,
Go right ahead.
I have not been served with that. You have the exhibits for that were filed with the court right for the last hearing.
Saying that, Mr. Jake Snyder, I do not have them.
I'm sure I can find that.
You have not been served, but you also at the same time want to insist that I've received something which I have not. So we need to figure it out here.
Okay, well, I don't know what date those exhibits were served. It was right before, it was the morning before the last hearing, whatever date that was. I don't know what date it was.
Craig, can we just get an agreement, get an order that you'll answer my discovery within 21 days?
I still haven't been served as of today with all of your stuff. I've never got served. In fact, you on purpose removed me from the service.
I wouldn't do
Now,
that.
why
Craig.
did that occur? I don't know. I know I wasn't served.
Okay.
I
I didn't and would never personally remove you from service. There's no benefit to me to do this. I wouldn't do it anyway.
Well, that's what the
I just-
county clerk says.
Oh,
No.
Can we just get an agreement that I'll send it to you again today via email or service or whatever we need to do. Can we get agreement that you'll respond to it within 21 days?
Well, no, okay, I still haven't been served ever. But, and I'll find out why those exhibits didn't, they
Are
should.
you telling me, Mr. Shake Snyder, that you don't have a copy of that request for production and request for disclosure?
I don't know if I have that or not. I know it wasn't served with
I
me.
think you know whether you have it or not. Do you have it or not?
I don't know if I have. I don't think that I do. I have some of it that I've copied. In fact, the county clerk's office charged me for the copies of the original filings from Mr. Wood because I didn't get them, and I didn't know that I didn't get them until a long time afterwards. So I paid the county clerk for copies of all of that. So maybe I do have it, but I was never served. And that's what, per the county clerk's office. And
Okay.
there's one that got, but I will make sure that I get those exhibits filed if they weren't.
Mr. Woods, I'm gonna reschedule this for Wednesday morning when I have my other hearings, and I'm gonna give you an opportunity to visit with the county clerk between now and then.
Okay.
But you can go ahead and send those to Mr. Shake Snyder, which he apparently already has. But if he's gonna insist on strict compliance with the rules, then we'll go that direction.
Okay, Your Honor. I think, often we get, and I didn't anticipate this, to be honest with you. Crystal, I think, often gets some type of receipt whenever these things are e-served. I don't see these things, but I will investigate. And
Okay.
then I guess the hearing will be at what time? 10 on Wednesday?
Yeah, we'll put you down for Wednesday. If something changes, you and Mr. Shake Snyder can let Melissa know in my office.
Very good, Your Honor. Thank you.
Thank you, Your Honor.
Y'all take care. The lady for this. I did look at it. Okay, where's my docket sheet? Yeah. Okay. Perjury, can you hear me?
Yes, I can, Your Honor.
How do you pronounce your last name?
Treasurer.
Perjury.
Yes, sir.
All right, Mr. Woods, we're here on cause number 119368, the estate of Elizabeth Cole Travis, aka Elizabeth C. Travis, deceased. We're here today on a motion for summary judgment filed by Mr. Wood on May 26th of 2021, as well as a plea to the jurisdiction that he filed on July 7th of 2021 with respect to a declaratory judgment action relating to a trust. And I will tell you, gentlemen, that I got here at 6:20 this morning. I tried to read through everything. I still have not completed reading Senator Parker's deposition testimony. But I have read the motion for summary judgment, the response, the plea to the jurisdiction, and the petition for declaratory judgment. I still have some of the exhibits that are attached to those documents that I need to look at. So I guess the main question here this morning on the motion for summary judgment, Mr. Pajeri, is that Mr. Woods has filed a traditional summary judgment motion as well as a no evidence summary judgment motion. And I guess I need to hear what your response brings up as justiciable items with respect to those motions.
Certainly, Your Honor. Before I begin that, if I may, the plea to the jurisdiction wasn't properly set. It was noticed to me for this past Saturday, July 10th. And I did not receive a notice that it was going to be heard today, nor even if it was set properly, did I have time to prepare a response to it since it was set less than one business day in advance.
That I will not make that today. I will give you an opportunity up until Friday to file a response to that.
Absolutely.
That's correct, Your Honor. There were some issues regarding the timeliness, and then once we prepared it, we even actually, it was supposed to be set for today, and we put 10 a.m. on June 10th. So there were a couple of issues with the notice. So
That's fine. So let's talk about your response to his summary judgment motion. He says, with respect to lack of testamentary capacity and undue influence, that you failed to bring forth any facts that would show that those were applicable in the present circumstances. So let's hear from you, Mr. Pajeri.
Yes, Your Honor. So the no evidence grounds were asserted against the undue influence part of our contest. As evidence in support of our claim of undue influence, we submitted to the judge with our response excerpts from our client's testimony where he discusses not only anecdotes that he's heard from other people involved in this case, but things that he has personally seen and experienced himself that have occurred between himself and his mother and Mr. Wood's client, Judith. On page 4 to 5 of our response, we lay out each instance in his deposition where these things are discussed. And it's fairly extensive. For instance, the mental and verbal abuse that that he himself has witnessed at family reunions and which has been relayed to him by others. There are instances where just a moment, let me find. Various witnesses confirmed that Judith would verbally abuse the decedent, at one point yelling at her to get off her lazy ass and get her own water, and that was just in the middle of just a household meeting visit with some family members. and for context, decedent is in a wheelchair, was in a wheelchair at the time. We have presented the court with evidence that Judith and her daughter Valerie, when they began this campaign in the early 2000s, they stopped working altogether, and instead the decedent ended up paying all of Judith's and Valerie's bills. Large sums of money began disappearing from accounts, including ones that were up to that point jointly owned by William and the decedent. The decedent began to pay outrageous amounts for Judith's benefit and for Valerie's benefit, Judith's daughter. That is evidence of this ongoing undue influence that occurred over the course of many years. The note which we submitted to the court as part of the exhibit to the deposition of our client, that was a note that was taped to decedent's front door when William went to visit. He took the note and has the original note with him still. The decedent wrote this note, which essentially said that William was not allowed on the property, but it was indicated to our client that she was not writing it under her own will. And in fact, also on the note, she wrote a secret note, apparently after Judith saw it, that says that she did want to talk to her client. Hang on just a moment. What up? That was a deposition exhibit 10. We did attach it at the end of our response exhibit A.
Okay, there.
So it's on there, and so there's it's signed, but it's also if you can see, it's written in big block letters. William believes that either the decedent was forced to write it like that, or that Judith or Valerie in fact wrote it, because you can see at the bottom. I don't know how clear your copy is, but I can try and submit my copy of it. It's not very, it's not a good photocopy. You can't quite see all of it, but we do have the original. And it says, "I need to talk to you" in cursive in a different font. That's clearly the decedent trying to get in contact with William, who's being told that he can't be on the property. To us, that is at the very, we are not here today to try and conclusively prove our case. We are raising a fact issue here on undue influence. And I think that that note alone is sufficient evidence that we would need to be allowed to show the jury, have the jury judge and weigh the credibility of the testimony between Judith and William and these exhibits, and be able to decide these things for themselves.
I can't see this copy of this exhibit 10 that's on here. What does it say at the bottom?
At the bottom, it says, "I need to talk to you," and it's signed E. Travis. And I will have our clerk try and get the original and get a better photocopy of it, since I do see that this one's a little bit light. But our client still does have the original still in his possession. The other evidence we have in support are we have various witnesses that we would be calling at this point to testify to the relationship between William and Judith, William and Elizabeth, and Judith and Elizabeth. Many of these are referred to in our client's deposition. We've named a number of them in our responses to requests for disclosure, and we are preparing to name more. Our client has gotten us contact information for several others that we'd be able to call at this point to discuss some of these incidents from their own personal point of view. So to us, that's sufficient evidence to raise a genuine issue of material fact on undue influence. As for capacity, essentially what the motion does as far as capacity is concerned is that it raises no evidence but it also includes the argument that the evidence conclusively negates the claim of undue influence. Either way, we definitely, I'm sorry?
Again,
Oh, sorry, we got
are you saying
They-
that there's duty to conclusively negate undue influence?
they've attempted to conclusively negate, I'm sorry, that they are attempting to conclusively establish testimony capacity. At this point in the will contest, Judith Erickson has the burden of proof to prove capacity because the will has not yet been admitted to probate. So in order for them to succeed on summary judgment based on capacity, they wouldn't need to challenge us on a no evidence point. They would need to affirmatively, conclusively prove capacity. And I do not believe that they have done so. I think that the evidence is far lacking in what they would need to prove affirmatively as to the decedent's capacity, given her advanced age, her mental and physical condition at the time, which even I don't think Judith can deny. She was in a wheelchair. She was having trouble remembering individuals. But again, to refocus, the issue being they would have to conclusively prove capacity at the time of the execution of the will. And I don't think they do that through the testimony of Tracy Brown and Carl Parker. I know you mentioned you hadn't fully read through Mr. Parker's deposition testimony, but if you do read through it, the parts that they focus on are parts, first of all, we've objected to as hearsay, because it's statements by Elizabeth, allegedly, to Mr. Parker, which don't fall under any hearsay exceptions at the time, but they are offering to prove the truth of the matter asserted. So we have those objections preserved in our, we filed a separate objection to summary judgment evidence as well. As for the rest of the deposition, you can clearly see in there where Mr. Parker, the drafting attorney and executing attorney, didn't do any kind of mini mental state examination, didn't do any kind of questioning to make sure that she had capacity. He sort of took it on faith that she did, which in many circumstances is fine, but it's simply not conclusive evidence, of her capacity. Especially because, like I said at the time, she was clearly of advanced age and in poorer health. As for what conclusive evidence would be, what a court could accept at this stage in a proceeding at a summary judgment level of the case to prove conclusively that someone had capacity, I don't see any case law or otherwise showing that you can accept anything less than medical records and even medical expert testimony at this point to conclusively prove capacity. That's an issue that has to be, until there is that level of evidence, would need to be presented to a jury. And I know in many cases, you don't present medical testimony one way or the other. You have the parties and the people involved discuss it at trial to a jury and have the jury judge the credibility of the witnesses, the weight of the testimony. Each witness testifying as to what they thought their mother or whoever's capacity was. But at the summary judgment stage,
Contestants will could make a assertion of lack of testamentary capacity and it would require a jury trial?
I'm sorry?
Okay.
I'm sorry, I couldn't hear some of that.
Okay, are you telling me that a contestant to a will can make a bald assertion without further fact of lack of testamentary capacity, and if the movement for the entry of the will to probate did not have a physician statement that to conclusively prove it, that a jury trial would be required in all circumstances?
In a sense, yes. We do not at this time bear the burden to prove capacity. It's Judith Erickson's burden at this point to prove capacity. Had this will already been admitted to probate, we would absolutely be subject to, Judith could file a no evidence summary judgment motion at that point, if we had the burden to prove a lack of capacity. This is a case where the will has not yet been admitted to probate. Under the law, Judith still has the burden of proof, which she admits in her motion, and in our view, in this summary judgment proceeding, hasn't presented conclusive evidence of capacity. She's produced. Let me put it this way: if we were moving for no evidence summary judgment at this stage, saying there is no evidence of capacity, she would likely survive that. She has presented some evidence. She's presented, like I said, the drafting attorney's testimony, which the jury could then, view that testimony and weigh its credibility and accept it or reject it. But in order for them to succeed on this, at this stage, at a summary judgment stage, they have the burden, and so they would have to conclusively prove a capacity, rather. It's a matter of burdens at this point. As for our evidence of incapacity, if the court would like to hear the evidence we've submitted in support of capacity, is that it is again from our client's deposition, for the most part, where he discusses her inability to remember names. He would say, I would visit with her, and this was before she was being completely isolated. So it was as early as 2004 or so, well before the will was done. He would visit with her, and she would forget his name entirely. She would go through. She had 5 kids, and she'd go through every name before she got to his. That's direct evidence from our client of an interaction he had with her. As for other evidence of incapacity, we would, again, some of these other witnesses would be able to testify to her lack of capacity at the time of the execution of the will. But I do think, Your Honor, we are going to stand on our argument at this point that because they have the burden, they would have to conclusively prove the existence of testamentary capacity in order to succeed on their summary judgment motion.
Hey, Mr. Wood.
Your Honor, I'm going to first talk about capacity. I think that we have met our prima facie burden to show that Mrs. Travis had capacity when she executed the will in October of 2015. First off, the will is a self-proved will with a proper self-proved affidavit. Second off, we have both Carl Parker's testimony and we have Tracy Brown's testimony regarding Mrs. Travis's capacity on the day that she executed the will. When the court has more time available to go through, what the court will find is that the meeting with Mr. Parker, Senator Parker, occurred on the same day that the will was drafted, and then the will was executed on that same day as well. So it was a one-day process. And both of them testify clearly and strongly that on the day that she signed the will, she had capacity to do so. The flip side of that is, because we've met our prima facie burden to show capacity, there is nothing from the contestants to show that she had any capacity, any incapacity. There are no medical records at all that have been admitted to show that. There's no evidence at all that she had dementia or any other problem. And the thing that's really important about all of the evidence that the contestant has is it's so old and so long before she executed the will, it has no relevance whatsoever, either capacity or undue influence. If you actually look at the dates, and I went through it, and I will tell you, Your Honor, that William Travis is probably in my top 2 most evasive witnesses that I've ever deposed in 33 years. And you can see that when you read the deposition. But we drilled down on the dates, and he had not seen his mom since 2008, I believe. Roughly 7 years before she executed this will. So there's no way any of the testimony that he has about either undue influence or capacity has any relevance to the October 2015 will. And so that's really all I have to say about capacity, because I think we've met our burden, and there's no evidence otherwise to contradict that or to create any type of fact issue. Now, as it pertains to undue influence, I think it's important for the court to know that in 2009, Mrs. Travis sued William Barrett Travis in the 60th District Court of here in Jefferson County. And this was a suit to recover monies that were owed to Mrs. Travis by William Barrett Travis, because he had defaulted on a promissory note that Mrs. Travis then had to make good on. And that suit is still pending. In fact, on it was June 19th, 2019, Judge Sanderson signed an order transferring that case to this court, and that case is still part of this estate proceeding. And it's, since that happened, it's just not moved forward, but it's still there, it's pending, and it's still a viable litigation. So the fact that the reason why I say that is a very unusual circumstance where you have a situation where a mother has had to sue the son or a sibling. And so there's obviously sufficient animosity between the parties that this lawsuit was filed and has remained pending to this day. Now, the evidence that we put in as to undue influence was, again, that Senator Parker's testimony that he knew Mrs. Travis. He'd gone to church with Mrs. Travis for many years. That she had approached him, that she was a strong-willed woman, that she was clear with what she wanted, and she was very determined. My client, although she drove Mrs. Travis to the law office that day, she did not sit in, she did not participate in the discussions with Senator Parker. She did not sit in and was there when the actual will was executed. In fact, when you look at what the old 8-year-old evidence is, there is not one shred of evidence that addresses any of the Rothermel factors that you look at for undue influence. And I think there's 8 or 9 of them. And just none of those are existence. There is no testimony or no evidence that there was undue influence exerted in or around the time that this will was executed. They also argue that this was an unnatural distribution, and I would argue that no, that's not the case. That's one of the Rothermel factors, is because the will does not leave everything to my client. It leaves everything equally to my client and the other daughter, who is Bertha Tina Travis. There is another son, Michael, and I was looking through my notes today when I was preparing, and nobody talks about him. I think he may be in a penitentiary life, but that's just off the top of my head.
What's the date of the will?
It is October 28th, 2015.
And the date of death is in 2017?
I believe that's correct, Your Honor. Yes, sir. I didn't write that down, to be honest with you, but I believe that that's right.
December of 2017.
It's about date of death. And all right, anything further?
No, Your Honor, I don't believe I have any other additional arguments.
Pardon me,
I have nothing else additional to argue.
sir?
I'm sorry, I have nothing else additional to argue.
Yes, I'm talking to Mr.
Oh.
Bajir.
Yes, just a brief response to some of the points that Mr. Wood brought up. First of all, I want to discuss his statement that a lot of these facts happened so long before the 2015 will. First of all, that's really a result of the undue influence that we're talking about, the isolation, which is one of the factors, by the way, of undue influence. That William was no longer allowed to see his mother based on Judith's interference with that relationship. And any evidence that he would present as to her incapacity in any time before 2015 is going to be circumstantial evidence that she did not have capacity at the time of the execution of the will. Very rarely does someone recover that level of mental capacity once they've lost it. So in our view, that bolsters our case rather than undermines it, because it presents evidence of incapacity that occurred even well before the execution of the will.
Is there anything in 2008 and 2017, did anybody file anything with Adult Protective Services?
I'm trying to think back. I don't believe my client pursued anything with Adult Protective Services, as far as I know.
Your client
It's not discussed in his.
make a request to take out a guardianship over his mother?
No, I don't believe he did during that time. I have not. It was not discussed in his deposition, and I have not. I don't believe. I know I have not. I don't know if anybody else at our firm has asked whether or not he ever pursued a guardianship. But I at this point, I can't say one or the other.
Gotcha.
I'm sorry.
Go right ahead.
The other point that I want to bring up is that Mr. Wood consistently talked about the prima facie case that he has, which I want to just note is not conclusive evidence. It is, the fact that a will has been signed by witnesses. It's under the law, prima facie evidence of its validity, but it is not conclusive. And as far as I have seen in my research, it does not shift a burden of proof for summary judgment purposes. The 2009 lawsuit, Mr. Parker admits in his deposition, and we have presented the court with this testimony, that the decedent had severe reservations about going forward with that lawsuit in the first place, and that she did not go forward with it after 2009. That's presented in Carl Parker's testimony on page 20 of his deposition. And then we have, as for the no evidence of undue influence and the assertion or implication that the will was done completely without the influence of Judith. It is also in Mr. Parker's deposition testimony that he knew Judith separately from his church, and that that at times Judith would call his office on her own about decedent's estate. He didn't discuss what they talked about in his deposition. He didn't say what they discussed during those phone calls, but he does admit on page 13 of his deposition that Judith would call his office about decedent's estate. And so we present that as evidence of undue influence, of Judith working behind the scenes to make sure that this estate planning benefited herself. Now, as for whether or not it benefits Bertha as well, yes, it does. The will clearly leaves half the estate to Bertha, to Tina as well. That is not evidence against undue influence by Judith. That's simply evidence of a conspiracy between her and Tina, or one daughter taking advantage of the mother to benefit herself and her sister. That doesn't mean it is not a uneven and unequal distribution of property. It very clearly is. It cuts out, the decedent's two sons, which is again yet another one of the factors that go to support undue influence. And I believe that's all my response that I have for Mr. Wood's argument at this time.
Anything else?
No, Your Honor.
Okay. I'm gonna take a little bit more time and spend more time reviewing the exhibits to the various motions. I'm gonna wait until next Monday to start reading it because I'm gonna wait for the response to the plea to the jurisdiction. It would be my suggestion, just as a preparatory matter, and I'm not indicating one way or another how I'm going to rule, but I would suggest that the parties go ahead and discuss a scheduling order to dispose of this matter by trial. This decedent died in 2017. I don't want this thing hanging around much longer, so I'd prefer to get it to trial sooner rather than later if we in fact go to a trial. And so be helpful to the court if y'all went ahead and discussed in advance how y'all are going to get there and in what time frame and what additional discovery you need. But I will read through the motions and exhibits and deposition testimony again. I will tell you, Mr. Pajori, that I'm going to be looking at evidence that as far as testamentary capacity that is more closely chronologically more closely related to the 2015 execution of the document. And I think that's it. I appreciate y'all's time today. Let us know if there's anything else the court needs to consider. In the interim, I'll wait for your response to plead the jurisdiction. And
Okay, and you would like that before Friday?
I would like it if you run into a problem, please call the court and we
Okay,
can talk.
understood. All right.
I mean, if you call the court, let Mr. Woods know that you're going to call me.
Yeah, okay.
All righty.
All right.
Thank you, Your Honor.
Thank you.
Good week.
All right, you too.